Okay. Torts is one of the most, how should I say this? One of the heaviest subjects in the first year law school in the US. Usually you take either 5-unit course or 2 3-unit courses. We'll try to learn that in an hour or two. Okay? So you will basically get a general structure. Okay, all right. Torts. So you learn about 3 causes of action. You already know what cause of action is. Intentional torts. Okay, when I say something loud, please repeat after me. Intentional torts. Negligence. Strict liability. Okay. Intentional torts is when defendant engages in some affirmative act towards some sort of harm. For instance, like threatening, throw a rock at you, or actually throwing a rock. Okay. So some harm is intended toward another person. That's when intentional tort is applied. What are the actions that have been traditionally considered clearly harmful or intended to be harmful? Well, like touching another person or causing another person fear of being touched. Okay. Can you think of other actions that consider me. If I do something, right? Like, if I do something against you, or in what actions will you assume that I meant some harm against you? When I push you down the ground, or if I say something bad and false about you, spread false rumors about you, what else? What if this shouldn't happen, but if I enter a wrong grade into the database at the end of the semester. So traditionally, there are actions that are considered to be harmful, or there are those actions that the society has inferred harmful, some sort of direction toward the harm. Those things are considered intentional torts. So that constitute one body of law. The second body of law is about all other actions not categorized under intentional torts. So no proof of intentional act is required, but instead you have to prove some sort of fault. Okay? So most accidents fall under negligence. 그래서 민법 750조의 고의 또는 과실이라고 했을 때 고의는 intentional tort에 들어가고 negligence, 과실은 negligence에 들어가고. How do you prove a fault? Failure to take a precaution. 그러니까 어떤 주의 의무를 다하지 않은 것을 입증을 해야죠. But if the defendant takes all precautions that are available to them, then there is no cause of action. 주의 의무를 다하면 남에게 피해를 줬어도 책임이 없다라는 게 이 과실법리의 핵심입니다. 그래서 뭐가 주의 의무냐가 제일 중요해요. 인텐셔널 톨트는 그런 걸 따질 이유가 없죠. 자기가 주의를 다해서 타인에게 해를 끼치려고 한 거기 때문에 그 주의를 다했다는 게 고려 대상이 아니에요. 자기가 원했던 행동을 한 거기 때문에. 네글리전스는 자기가 원했던 행동을 한 게 아니기 때문에 그 과실에 대한 평가를 해야 되는 겁니다. 어떤 잘못이 있지 않은, 어떤 본인의 과실 때문에 원했던 대로 결과가 나오지 않은 것인지, 인텐셔널 톨트는 자기가 원했던 결과대로 그걸 가지고 책임을 지우는 것이고요. 자, 근데 우리나라에는 없는 새로운, so this is one body of law that this is one difference that you can proudly tell your friends when they ask you, so what's the difference between American tort law and Korean tort law? Well, you tell them there is this body of law called strict liability. 무과실 책임입니다. So you don't need proof of either failure or intentional act. But it applies to inherently ultra-hazardous activities. Inherently ultra-hazardous activities. Okay? So what are inherently ultra-hazardous activities? What are examples? Using explosives. Okay? 그래서 불꽃놀이, 또 뭐 건물 철거 사업하는 사람들, 특히 폭약으로 하는 사람들, 또는 아주 맹수를 기르는 사람들. These are considered ultra-hazardous activities. So if you engage in ultra-hazardous activities, even if you didn't intend any harm, even if you took all the scientifically available precautions that are available, that were available, you are strictly liable for all the harms that resulted. That's the idea behind strict liability. It doesn't matter whether you meant it. It doesn't matter what. It doesn't matter how careful you are. No matter you are 110 times careful or 110% careful, if harm resulted, if damage resulted, you are responsible. If you engage in ultra-hazardous activity. There was one ultra-hazardous activity last week. SpaceX rocket, Elon Musk, you know, the CEO of the car Tesla, he's trying to send a civilian rocket into space and the rocket exploded. Let's say because of the shock, let's say some houses or some houses just broke down because of the shock. Or at least some windows were broken because of the shock. Will Elon Musk be liable for the broken windows? Yes, because he was working with ultra-hazardous equipment that had enormous explosive potential. Okay? One exception is product liability, but I don't know whether we should call it a exception, but so product liability law is also called strict liability because you are making, you are subjecting a large number of people to the same harm if you produce something that has a defect and put into the commerce, put into the flow of the products. So mass production is also considered hazardous. So manufacturer is strictly liable to all defects remaining after taking all precautions scientifically available to him or her. So for instance, let's say I sold 1 million knives, kitchen knives. And let's say out of 1 million, one of them had a defect. So when someone is using it, a blade was, cracked and piece of it flew away to harm a bystander. No matter how carefully you made the product, no matter how carefully you made the kitchen knives, no matter how scientifically cutting edge technology you applied to make the kitchen knives, you are still responsible for the harm caused by the defective knife. It's in that sense that product liability is also considered strict liability. Okay? Now you can see that the reason behind strict liability, the reason behind product liability is different from the reason behind strict liability, but we still call product liability strict liability because manufacturers often present a defense that they took all the precautions, all the scientifically available precautions, but those arguments, those defenses are not recognized by the courts. The courts say, well, even if you are that careful, you are still responsible for selling that many knives. So the courts are saying something like, if you're not sure about the safety of the product, you should never mass produce it. Okay? That's strict liability. Now we're going to talk about all three causes of action one at a time. Intentional torts. Battery is intentional contact. Okay? Repeat after me. Battery. 이제 battery를 일반적으로 쓰면 이제 폭행 뭐 이렇게 번역이 되는데 꼭 뭐 주먹으로 때리고 그런 거 아니더라도 battery가 인정이 됩니다. 그러니까 원치 않는 접촉. 뭐 대표적으로 그러니까 어떤 어떤 강한 압력이나 이런 걸 동반하지 않아도 배터리가 인정되는 사건들은 많이 있는데 대표적인 게 이제 성폭행이죠. 네, sexual battery. So, I mean, a simpler example will be, so it's like if somebody kisses me against my will, that is also battery. And I can claim damages for being touched against my will. Now, you go to a department store, and if clerk selling perfumes or colognes spray you with perfume when you are just passing by, that is also battery. You are standing by the road on a rainy day, and there is a puddle of water on the ground. A car rushes by, splashing mud and water on you. That's also battery, right? Assault is threatening contact. The contact has been considered so harmful that threatening contact has been considered independent cause of action. Okay? So if I come to a person with a knife in my hand and make the motion of plunging my knife into his body, okay, even if I don't touch the person, it will be considered assault. Okay. Or if I take out a gun and point at someone, say, I'll shoot you. If you don't want to be shot, normally I'll say, I'll shoot you if you don't give me all your money, right? That's an assault. Okay. What if the person that I'm trying to threaten was facing that way, so didn't see the gun, right? Didn't see the gun that I'm pointing. And the person doesn't understand English. When I said, I'll shoot you if you don't give me all your money. Is that assault? Is that assault? What is assault? Intentional causing of fear of contact, right? Is there causing of fear of contact? No, because the person was not conscious of my threat, right? False imprisonment, that's another cause of action. That's when someone is confined, okay, against his or her will. So taking away freedom of movement of another person, that's another intentional tort cause of action. Fourth one is extreme and outrageous conduct. So if there is no contact, and if there is no threat of contact, and if there is no confinement, but there is a way that you can still make hell, raise hell for another person, and if you do that through extreme and outrageous conduct, you can also be held liable. What is an example of extreme and outrageous conduct? For instance, there was one case where, about trick or treat on Halloween, right? You go around houses, ask to be treated with candies, chocolates, right? But you want to trick the house host or hostesses, so you dress up into some monsters, animals, right? But let's say you did the tricking part so good that you really you dress up so realistically that the house host was so shocked to become unconscious upon sight, right? That happened. The house host sued the parents of the children who did the trick or treat, and they actually won. Okay? Another case. A hospital worker knew that a hospital worker to take revenge upon someone that happened to do an AIDS testing, who happened to have taken AIDS test at the hospital that he was working at. He forged the test result so that when the target of vengeance received a notice, it said he contracted AIDS. That's, it was intended to inflict emotional distress. It's outrageous, extreme. That hospital worker will be liable to the person who mistakenly believed, or, well, it was not by mistake, who was misled to believe that he contracted AIDS. Okay? That's extreme outrageous conduct. So far, these are intentional torts against the person. There are intentional torts against the properties. First is conversion, ousting of plaintiff's possession. So taking away somebody's possession. So if I take her mobile phone away so that she can never use it, that is conversion. Conversion into my possession. That's why it's called conversion. Oops, sorry. But I'm not taking away, I'm not converting it into my possession. But if I'm interfering with her using the phone, okay, then that's considered trespass to chattel. Okay, the mobile phone was not a good example. Let's think about a chair. If I take away her chair and sit on it, that's conversion. But if I somehow bother her so much that she cannot sit at that chair, if I somehow interfere with her attempt to sit at the chair, either by pulling it from behind or putting something on the chair, pouring water over the chair so that she cannot sit on it, that will be trespass to chattel. chattel 이제 동산 chattel이라고 합니다. Okay, so conversion, trespass, chattel, those are intentional torts against personal properties. Trespass and nuisance are intentional torts against the real properties, 부동산. And same thing, ousting of plaintiff's possession of real property is trespass. So let's say it's somebody's land I go inside there and I stand there, then the real owner cannot use the part of the land that I'm standing on, right? I ousted the possession of that part of the land from his possession, right? That's trespass. 침입이라고 번역되죠. 딱 맞아요. 네. Nuisance is interference with plaintiff's real property. I don't actually go inside, but I can still make it difficult for the person to use the land. How can I do that? By making tons of noises, or smell, or strong light, or sometimes by removing light, right? By building like high-rise fences so that the neighboring land, 조망권이죠. The neighboring land cannot enjoy the light of the sun. That will be considered nuisance. These are the defenses to intentional torts. 항변이죠, 항변. Consent. Self-defense. 정당방위. Defense of, 그러니까 이게 defense of self-defense죠, 그죠? 정당방위라는 항변이죠, 항변. 요 디펜스하고 이 디펜스하고는 지금 다른 거죠. 그건 이제 법적 공방을 벌일 때 방어를 얘기하는 거고, 이거는 이제 현실 세계에서. And then you have defense of others, defense of property. Defense of others, defense of property. So to protect your home, let's say you beat the hell out of a burglar who trespassed into your property, you can raise defense of property. Of course, if the force applied in defense is excessive, then the defense will not be recognized. But that's something you will learn in your 민법 class as well. So I'm not going to go into that myself. And then here is a defense of necessity. 이건 민법에서 배운 뭘 것 같아요? Defense of necessity. 어쩔 수 없이 필수 불가결해서 뭔가를 하는 경우. 이건 이제 긴급 피난, 긴급 피난. 그러니까 요 위에 있는 거는 어떻게 다르냐면, 요 위에 있는 거는 누가 이제 공격을 해오는 사람이 있어서 그걸 막기 위해서 하는 게 이제 하는 거라서 디펜스란 말이 들어간 거고, necessity는 누가 공격을 하는 건 아닌데, 뭐 날씨가 나쁘다거나, 뭔가 이제 큰 사고가 일어나서 그 사고의 피해를 막기 위해서 어떤 행위를, 뭐 예를 들어서 지진이 났기 때문에 사람을 빨리 이동시키기 위해서 차를 훔쳤다. Okay, you did that. What did you just commit? Conversion. Good. You committed conversion, but your defense will be what? Defense of necessity, right? Okay, that's intentional tort. Okay, is this fun? Boring, right? There's not the typical way that class is taught. You have to read tons of cases on each of the points of law, and we have to discuss those cases normally. But this is the easier way, or Well, this saves a lot of time and efforts. So let's move on. Negligence. Okay. And then, let me see. Good. Negligence is a little bit more complicated, and actually negligence takes up 90% of torts law learning. So all actions not falling under intentional tort are covered, and there is only one negligence, one cause of action of negligence, and the question you ask is whether there is a breach of duty. So breach of duty, 그러니까 주의의무 위반, factually and legally causing damages. Then there is intentional tort. Okay, so breach of duty, factually and legally causing damages. What do we mean by that? Okay, breach. The question you ask is, did defendant's failure fall below the applicable standard of conduct? That's the question you ask. But usually, defendant's conduct is already fixed at trial court, right? Because the jury resolve the question of fact. So what the defendant did is already fixed. Then the question you ask is, what is the applicable standard of conduct? So that's the question of breach of duty. Now, I put things out of order because this is more commonsensical to understand. Factual causation. It's also called but-for causation because the question you ask is, would the damages have taken place even before defendant's failure? More exactly, defendant's breach of duty. 이거 바꿔 쓰세요. Now, if some damage would have happened regardless of defendant's conduct, should the defendant be responsible for what happened? What do you think? No, right? If it was going to happen anyway, then defendant should not be held liable for that. That's the idea. So that's one thing you should check, whether there is a but-for causation. Okay, what's the typical cause? All right, let's think about this. There is a let's say there is a crossroad and defendant's car was being driven negligently, and actually defendant, so this is defendant's car, and he breached duty, he breached the statutory duty of turning on headlight. Okay. On the breach of duty question, one applicable standard of conduct is, following law. If the law says you have to turn on a headlight when it's dark, you have to. If you didn't, that is breach of duty. So let's say there is a breach of duty, okay? But as the car was moving, it fell off. It fell off the road into plaintiff's car. Now, breach of duty is not turning on headlight, okay? No headlight. Is there factual causation? Is there but-for causation between not turning on headlight well, one more thing. Let's assume that defendant's car fell off the road because as he was driving, fell asleep. Okay, the defendant fell asleep, right? So the car fell off the road onto plaintiff's car. Is there factual causation between defendant's breach of duty of not turning on the headlight and the damage that plaintiff suffered? What do you think? Is there but-for causation?
When you say it fell off of the bridge down to the road?
Yeah. It's an overpass. Okay. 차가 이렇게 가고 있고 완고차가 하는데 차가 떨어져서 Is there but-for causation? What do you think? No, right? Because not turning on the headlight had nothing to do with defendant's car falling on the plaintiff's car. Okay. Let's say, there's an even easier case. Let's say I don't have a driving license, right? And I got into an accident while I was speeding. Okay. Is there but-for causation between my breach of duty of having a driving license or driving with a license and the damage that I caused by going into an accident? Is there but-for causation? But for not having the license, would I have gone into the accident? That's the answer you ask. Depending on whether license keeps you from speeding. Well, usually, just assume that license has nothing to do with the speeding. No but-for causation there either. Okay, all right. So that's factual causation. How about legal causation? The question you ask, it's also called proximate causation. The question you ask is defendant's failure to proximate okay, 저기 take out 2. Okay, so the question you ask is defendant's failure proximate enough to be given legal effect. Example is a teacher, it's not teaching, teacher announcing a wrong class time causing a student to take an early bus which goes into an accident. Okay, 뭐 보강을 해야 된다고 생각해봐요. And instead of a Monday, I said Tuesday, right? So a student coming to the school on Tuesday gets into a bus and the bus happened to go into an accident and the student gets injured. is there but-for causation between my mistake, my breach of duty, okay, my breach of teacher's duty of announcing class time properly, and is there but-for causation between my breach of duty of announcing class time correctly and the student's injury? Is there a but-for causation? Yes, because if I didn't announce the time by mistake, okay, if I announced the class time correctly, then the student would not have taken the bus on Tuesday, would have taken the bus on Monday, which would have been presumably safer, right? So there is a but-for causation, but will the court hold me liable for the student's injury? No, because the causation is just too remote, okay? It's not proximate. Remote versus proximate. Damages. You also have to prove damages. What damages have resulted? Usually you don't have to prove any damages in intentional torts. The damages are presumed. But for negligence, you have to prove damages. So, okay. And then the last element that you have to satisfy is whether defendant has any duty to the plaintiff. Whether defendant did anything in relation to plaintiff. So for instance, I'm a police officer and let's say I just dozed off on duty and didn't take 911 call, right? But let's say, so there was a breach of duty, okay? But because of the missed 911 call, let's say some planned murder or planned crime went as planned. Okay, some crime took place, and the police lost a valuable opportunity to stop it from happening. Here, there is a breach of duty because the police officer took a nap while on duty. And there's a factual causation because if the police officer took the 911 call, he might have been able to stop the crime from happening. There is a proximate causation because, presumably the call came from the victim, and the police officer could have, given the victim advice, given directions about where to take shelter, things like that. And there's a damage that the victim suffered. So all four elements are met, but still the question is, does the police officer have affirmative duty to protect people? Okay. That is a very legal question, and I'm going to give you cases about one of the cases is called Soldano, and you'll read those cases and we'll discuss those cases. And And another situation is when defendant did not engage in any voluntary action. So for instance, you're an adult, you kind of know how to swim. You are not an Olympic swimmer, but you learned how to swim. And at the swimming pool there is a 4-year-old about to drown. Let's say you didn't do anything. Okay? Is there a breach of duty? Or let's say the applicable standard is a reasonable person standard, right? What reasonable person would have done? Let's say that's the applicable standard of conduct. A reasonable person will try to save the child from drowning, right? So if you don't do anything, then you breach the duty. Is there factual causation? Yes. The child drowned because your refusal to try to save the child. Is there proximate causation? Yes. There is a direct causation between your not saving the child and the child not being saved. There's no more direct relationship that's imaginable. Is there damage? Hey, the child died. All 4 elements are met, but in the law, judges say, well, you still are not liable because you didn't do anything to contribute to the harm. Right? You learned about this, right, in your Korean law class, Korean civil law class. In American tort law, it's considered a duty question. Okay? Does police officer have a duty? Does police officer have affirmative duty to stop crime from happening? Do ordinary people have affirmative duty to stop others from being injured? Same thing with the lawyers. Do lawyers have affirmative duty to stop crimes from happening? For instance, let's say you have a client who is about to commit a crime. Do you have affirmative duty to alert the authorities so that your client can be caught? All of those questions arise because defendant did not engage in any voluntary conduct. Okay, let's take things one at a time. Okay. So whether defendant has any duty, that question can be broken into there's 2 steps. Whether defendant engaged in any voluntary act that's causally related to plaintiff's damage. If defendant did anything, then defendant is held to have a duty of care for plaintiff's injury. So driving a car, okay, that's itself not a breach of duty, but that is a conduct, that is affirmative and voluntary conduct the defendant engaged in. And if due to some accident, plaintiff gets injured by the defendant, then defendant's conduct should be evaluated because defendant engaged in that voluntary conduct. Now, even if there is no voluntary conduct, by the way, 뭐를 하지 않은 잘못을 non-feasance라고 해요. 따라해보세요. non-feasance. 뭔가 잘못을 하는 거를 malfeasance라고 해요. 따라해보세요. malfeasance. 자, 이거 우리말로 뭐라고 그래요? 그렇죠. 부작위, 작위. Now, if there is no voluntary act, defendant may have a duty of care in following cases. Special relationship with the plaintiff. Teacher, student, parent, child. So, if the person who was at the swimming pool was a teacher of the 4-year-old child that just drowned, then the teacher is responsible for the death of the child, even if the teacher didn't do anything. Same thing when the person standing by the pool, swimming pool, is the parent of the child who just drowned. By the way, you don't have to write down everything. I'll put on blackboard, okay? And the second exception is when defendant has special relationship with a third party that caused damages to plaintiff. So let's say you're a psychiatrist and one of your patient keeps talking about this woman named Tatiana, and your patient loves her so much to want to kill her. 죽도록 사랑한다는 뜻이죠. And keeps talking about her. And as a psychiatrist, you know that she's a real person. Do you have a duty to alert Tatiana so that she can take shelter from your patient? What do you think? Think about that. All right. The third exception is employer-employee relationship and land occupier and whoever comes onto the land. Okay. So, employer-employee relationship, I don't need to explain much more because employer is responsible for what happens in the course of employment to the employee. Okay. Because the employer, by definition of employer, the employer is controlling all the conduct of employee, right? Land occupier, same thing. Land occupier controls everything about the land and then invites somebody come into the land, then the land occupier is responsible. So for instance, let's say one of the chairs you are sitting on is broken and you fall backward and suffer damages because of the chair breaking down. Who will you sue? Your lawyer. Who will you sue? You will sue the school because the school is the land occupier and you are invited to study at the school premise, even for a large fee. You definitely should sue school. Yes, next you will have to look at the chair and whether there is a defect and sue the chair manufacturer. But that will be hard because you'll have to know. You'll have to first check whether there is a defect. The product liability, the strict liability applies only when a defect is proven. But, I mean, you'll need some scientists to show the mechanical failure of a chair. So it's easier to sue the land occupier. So land occupier, and you know, in that scenario, the school didn't do anything, right? You come to the school, you are using the chair, you fall down because of the chair breaking, you get injured, the school didn't do anything. But because the school occupied the land and took care of everything about the land, the school will be held responsible. So that's another exception where a person with nonfeasance, right? Person with nonfeasance is can be held liable. Finally, undertaking. Repeat after me. Undertaking. Some act trying to help plaintiff but failure to take precaution. That's undertaking. Typical undertaking is this. Let's say it's a cold winter and somebody had the one too many drink and passed out right in front of the gate to his house. So that's defendant. Plaintiff passing by saw the defendant and is worried that he might freeze to death. So plaintiff help him up the stairs and put him sitting by the door under the porch so that, you know, he is warmer than lying on the cold concrete floor. But he's so drunk that he falls down the stair, rolls down the stairs to his death. Okay? Now, plaintiff didn't engage in any voluntary act that caused if there is any voluntary act that plaintiff engaged in, that was to help plaintiff, right? But what happened at the end? It put the plaintiff, this is not defendant, this is plaintiff. This is defendant, I'm sorry. So plaintiff was the drunkard and defendant helped him up the stairs, but because now he's upstairs, plaintiff rolled down the stairs to fall to his death. In a situation like this, defendant, although he engaged only in a beneficial conduct, because he was not careful, he put the plaintiff in a worse position than the beginning, right? So in that situation, defendant's conduct should be evaluated. So in that situation, you have to go back to the above 4, 1, 3, 4, 5, the 4 elements and see if all the elements are met. Okay. All right, any question, comment? Yes?
In the Korean law, in the Korean Kuocw,
Yeah.
They don't really differentiate.
Factual causation and proximate causation?
No. The intentional torts and negligence, they just simply teach us whether it's intentional negligence is not really important. The fact that the important part is that whether it's intentional or negligent, it doesn't. They don't differentiate the two very much. And is it different in the American system?
Very, very. Intentional tort lawsuits are much easier because there's not much to prove. Other than showing defendant's conduct, there's not much to prove. But if you try to sue somebody for negligence, you have to prove that defendant's conduct fell below a certain standard. There are 4 or 5 different theories about what the standard should be, but that's where the case fights happen, right? Finding compelling precedent and things like that. I think that the benefit of splitting the two is by splitting, you can broaden the coverage of negligence, because there you don't worry about any harmful intent of the parties. You just look at the defendant's conduct, you look at societal standard, so that way you can grab more actions you can grab a broader diversity of defendants' actions and try to bring them to justice. And you make intentional tort cases easier to deal with, because really, I mean, you don't have to talk about causation, you don't have to talk about standard of conduct. So that's the difference. Any other question, comment? Okay, none, good. I'll put some tort duty cases on Blackboard. Please read them for the class on Thursday. Next Tuesday, we'll do our first movie watching, and of course, so quiz, and we'll watch civil action, and I'll give you questions. I'll give you a problem set to solve while watching the movie. If you want, you can watch it yourself at home before coming to class. What I usually do is let you know the title so you can watch beforehand, and then have a copy available here, so through a notebook and all that. So if you want, you can watch it as you solve the problem set. Okay?
So we're not going to meet here?
No, we're going to meet here.
The whole movie?
No, I'm not going to show the whole movie. I'll just have it available so that if anyone wants to see certain relevant parts, they can see it. Okay? In terms of watching the movie itself, before the class, you know where to go. The title of the movie, 실러버스에 이미 있죠? Civil action 볼 겁니다. Civil action. 그래서 미리 보시고 오면 좋죠. 와서 보셔도 되고요. 자신 있으면. 예. 그러면은 2시간 반이니까 우리 수업 시간이 영화는 보통 100분이니까 한 번 보고 다시 볼 시간도 있으니까. 예. 하여간 그건 다음 주 얘기. 예. 자, any other question, comment? 예. Sure.
I don't really understand why they're technically evaluating the breach and duty.
You'll have to speak louder, not just today, but for every class. Yeah.
I don't really understand why
Uh-huh.
they're separately evaluating the concept of breach and duty, because I would think that duty is already kind of included in the evaluation of whether the defendant had the applicable standard of conduct.
Yeah. I'm not saying breach and duty are evaluated separately. So the duty question is more of a threshold question, right? It's not, what you just said is totally right. When you talk about breach of duty, all you need to ask is what applicable standard, what standard applies, because defendant's conduct is already fixed, right? Defendant's conduct is already fixed, and you need to know whether standard A is applicable or standard B is applicable, right? If standard A is applicable, then he breached the duty because it falls below the standard. If standard B is applicable, then he satisfied the standard, right? So it's just one question. But the duty question, right? The duty question that I'm going to give you the cases on is whether defendant should be even pulled into that kind of analysis at all when defendant didn't do anything about the whole situation. Okay? Defendant was, defendant engaged in nonfeasance, didn't do anything about the whole course of events. Why should defendant's conduct be held up to any standard when defendant didn't really do anything to contribute to the harm that was caused? I mean, there could be legal causation, there could be factual causation, but, like police officer, like the swimmer who didn't do anything to save the drowning child, right? That's a separate question. Think about it. I mean, just read the cases. You'll know what I'm talking about. There, the breach of duty question is entirely separate from the duty question. Okay, any other question, comment?
So for the next class, we have to read the two cases in this textbook and the two cases that you will upload?
Yeah.
Okay.
Yeah. Yes.
Are we going to take test quiz into these materials?
Yes. Yes.
The book reading and this.
Yep.
And are we going to have any break times
Between classes, if you want break time, we can take it. We'll just end 10 minutes later if you take 10-minute break. Okay. You like break time? Okay. Yes? No? Well, think about it and let me know in the next class. Yes?
So will the quiz be based on the film we're watching next week?
Yes, very, very much. It will be about what happens in the film.
I don't get it. You're saying the quiz is related to every single thing that we talked about, including the movie. So how many questions are there going to be? And like, if it covers every single thing, do we have to do every single thing?
No. A teacher only threatens to cover everything, but never covers everything in the exam. That's the whole idea behind quiz or exam. You are only threatened to cover everything.
So technically, there was no point in asking questions.
Like what? No. By asking questions, you learn the material better, and you are more likely to do better than others. So, anything else?
Are we going to watch movie without subtitles?
Huh? What?
Are we going to watch movie without subtitles?
It has.
So it's English subtitle at least.
Well, again, you can watch the movie yourself before coming into the classroom. Yeah.
What's the Korean title for the movie?
Civil action.
What year was it like made?
구글 다 있어요. 다. 저 제목의 영화는 지금 하나밖에 없어요. 유튜브에 보면 이미 올라와 있을 거예요.
Is it that old?
I also teach copyright in entertainment law class. Downloading a movie for your own consumption or consumption of your family members or equivalent, I think meaning boyfriends, is not a copyright violation. Okay? It's called private copying, and Korean copyright law has a special exception for private copying. So if you're not going to sell the files or upload the files, you are free to download files for your viewing. Okay? Any other question? All right, that's it. I'll see you Thursday.